You know, you look at these quiet suburban neighborhoods, and you'd never guess that sometimes they're the backdrop for some pretty high-stakes battles. Today, we're diving into one of those fights. It's a story about a townhome community, a multi-million-dollar repair project that completely fell apart, and one homeowner who accused her HOA board of flat-out breaking the law. So picture this. It's March 3rd, 2023, and this letter lands in the mailboxes of every homeowner at Val Vista Park Townhomes. A huge vote to fund critical repairs for painting, streets, and roofs had failed. And the takeaway was blunt. All major projects were now off the table, indefinitely. Basically, residents were left to just sit and watch their own property fall into disrepair. But for at least one homeowner, the failed vote wasn't even the real problem. She was convinced the entire process leading up to that vote was illegal. So she decided to take on her own volunteer HOA board. And that kicked off a legal hearing that, honestly, peels back the curtain on this huge gap between what we think our rights are as homeowners and what the law actually says.
Okay, so let's set the scene. Val Vista Park is dealing with some serious wear and tear. We're talking stucco that desperately needs painting, roofs that are getting old, and streets that are just falling apart. These are not small fixes. They are big, expensive problems you just can't kick down the road forever. So what's the board of directors' big idea? They propose something called a special assessment. If you're not familiar, it's basically a mandatory fee that every single homeowner has to pay on top of their normal monthly dues. The goal was to build up a multi-million-dollar war chest to finally tackle all these urgent repairs.
And listen, we are not talking about chump change here. The final plan that went to the homeowners would cost every single one of them a grand total of $2,500. They'd pay it in chunks, about $125 a month for 20 months. But still, for a lot of people, that is a major financial hit.
And when the vote happened, wow, it was incredibly close. The proposal got 20 votes for it and 23 against. But here's the catch. The community's own rules said it needed a 2/3 majority to pass. That's 29 votes. So it failed, but not by a lot. This community was clearly split right down the middle.
All right, so this failed vote is where homeowner Wanda Swartling really enters the picture. She wasn't just mad about the outcome. She was absolutely convinced that the board had cooked up the entire proposal behind closed doors, violating Arizona's open meeting law. So the heart of her suspicion, the real aha moment for her, was all about the timeline. Get this. On February 7th, homeowners get an email laying out multiple, pretty complicated options for how to fund this project. But then, just 2 weeks later, the official ballot goes out, and there's only one option. Her question was simple. How in the world did the board make that decision? At the hearing, Wanda put her question directly to the court. She argued that for the board to narrow all those options down to just one single proposal, they had to have discussed it. They had to have voted. So if that's what happened, where was the open meeting? And this all comes down to a really specific state law. Arizona's open meetings law is all about transparency. It says that if a quorum of the board, that just means enough members to actually make a decision, gets together to talk about association business, they have to do it in the open for everyone to see. You can't just make these huge decisions in a secret email chain or a group text. And she argued that is exactly what they did. But as you might expect, the board and their attorney had a very different take on the law. They basically argued that they did nothing wrong and that the homeowner was just fundamentally misunderstanding what they were required to do. The board's lawyer, Chad Gallacher, made their defense crystal clear. He said, and I'm paraphrasing here, look, there is no law anywhere that says a board has to hold a public board meeting just to call a members' meeting for a vote. He argued her entire complaint was based on a rule that just doesn't exist. Their entire argument really hinged on one specific bylaw in the community's own documents. Section 2.2 explicitly gives the board president the power to call a special meeting of the members. Now, their point is a little technical, but it's super important. The president didn't need the board to vote just so he could call a meeting for the members to vote. See the difference?
And they didn't stop there. The lawyer went on to argue that this whole thing didn't just come out of nowhere. He showed evidence of tons of public meetings over the last year. Meetings for all members, committee meetings, board meetings, where the community's shaky finances, the need for repairs, all of it was openly discussed. Their story was that this was the end of a long, very public process, not some secret plot. So now you've got two completely opposite stories, right? The homeowner sees a secret backroom deal, the board sees a totally legal public process. It was all up to an administrative law judge to sort through the mess. But The way he ended up ruling surprised pretty much everyone.
At one point, the homeowner tried to show evidence from past years to prove, in her words, a pattern of behavior of the board avoiding open meetings, but the judge shut that down immediately. He explained that her legal complaint was about very specific events, and he couldn't just expand the scope of the case to include this brand new theory that wasn't in her original filing.
And to make his point absolutely clear, the judge literally said his power was limited to what was written on her complaint form. He could only rule on whether the events around that one special meeting broke the law. His jurisdiction, as he put it, began and ended inside that box.
So this kept happening. Every time the homeowner tried to bring up these bigger issues, the board's lawyer would object and the judge had to agree with him. He basically said that her broader concerns about how the board operates might be totally valid, but legally speaking, that was a different issue for a different complaint in a different court.
So in the end, the whole case was decided on a legal technicality. The final ruling wasn't even about whether the board actually met in secret or not. It was about the fact that the complaint itself wasn't written broadly enough. It turns out the legal system requires a scalpel, and she had brought a hammer.
So what does all this mean for the millions of us living in HOAs who just want to know what the heck our board is up to? Well, this case really pulls back the curtain on this frustrating gap between our idea of transparency and what's actually required by law.
See, on one side, you have the homeowner's expectation, which is pretty straightforward, right? We think big decisions about our community and our money should be discussed out in the open. But on the other side, you have the legal reality, which is way more narrow and technical. A board's actions are only illegal if they break the exact letter of the law, and you can only challenge the specific violations you write down in a formal complaint.
And that really leaves us with the big, messy question at the heart of all of this. HOAs are run by our neighbors, unpaid volunteers who are just trying to get things done. And let's be honest, sometimes it's just more efficient to hash things out over email. But where do you draw the line? How does a community balance that need to be efficient with the fundamental right of every single homeowner to see how the sausage gets made? There really is no easy answer.